In a historic order, the Supreme Court of India on Wednesday froze the colonial-era sedition law under Section 124A of the Indian Penal Code. The Supreme Court also allowed the central government to re-examine and reconsider the provision of the Section 124A, which criminalises the offence of sedition. The court ordered that till the exercise of re-examination is complete, no case be registered under IPC Section 124A, and added that those already charged under it can approach courts for bail. The Chief Justice of India during the hearing in the Sedition Law case pointed out that Union of India agrees with the Prima facie opinion expressed by the court that the rigours of Section 124A is not in accordance with the current social milieu. Now let us take a look at some interesting facts of sedition cases filed in India in recent past. According to the Union Home Ministry data, a total of 326 cases were registered in India under the controversial sedition law between 2014 and 2019. But believe it, out of that, just 6 persons were convicted. During this period, the highest number of sedition cases were filed in Assam, that is 54 cases. Out of the cases registered, charge sheets were filed in 141 cases, while only 6 people were convicted for the offence in 6 years of the period discussed in the data, officials said. In Assam, out of the 54 sedition cases registered, charge sheets were filed in 26 cases and trials were completed in 25 cases. However, not a single case led to conviction between 2014 and 2019, according to the data. Jharkhand registered 40 cases under Section 124A during the 6 years, out of which charge sheets were filed in 29 cases and trials were completed in 16 cases. Only 1 person was convicted out of all these cases filed in the state. In Haryana, 31 cases were registered under the sedition law with charge sheets filed in 19 cases and trials completed in 6 cases. Here too, only 1 person was convicted. Bihar, Jammu and Kashmir and Kerala registered an equal number of cases, that is 25, under the sedition law. While Bihar and Kerala could not file charge sheet in any of the cases, Jammu and Kashmir filed it in 3 cases. However, no such case registered in the 3 states between 2014 and 2019 led to conviction. 22 sedition cases were filed in Karnataka with charge sheets filed in 17 cases, but trial could be completed in only 1 case. The state too had 0 conviction under sedition law in 6 years. 17 sedition cases were filed in Uttar Pradesh and 8 in West Bengal between 2014 and 2019. While charge sheets were filed in 8 cases in UP and in 5 cases in West Bengal, no one was convicted in the 2 states. In Delhi, 4 sedition cases were registered between 2014 and 2019. No charge sheet has been filed in any case, nor has anyone been convicted. No sedition case was filed in Meghalaya, Mizoram, Tripura, Sikkim, Andaman and Nicobar Islands, Lakshadweep, Puducherry, Chandigarh, Daman and Diu, and Dadra and Nagar Haveli in the 6-year period. 1 sedition case each was filed in Maharashtra in 2015, Punjab in 2015 and Uttarakhand in 2017. According to the Home Ministry data, 2019 saw the highest, that is 93 sedition cases registered in the country. In 2018, there were filed 70 such cases, followed by 51 in 2017, 47 in 2014, 35 in 2016 and 30 in 2015. 4 charge sheets were filed in the country in 2019 under sedition law, 38 in 2018, 27 in 2017, 16 in 2016, 14 in 2014 and 6 in 2015. Among the 6 convicted, 2 got the sentence in 2018 and 1 each in 2019, 2017, 2016 and 2014. The centre on Monday told the Supreme Court not to invest time in examining the validity of sedition law, as it has decided to go for reconsideration of the provisions by a competent forum. The centre also said it was cognizant of various views and concerns about civil liberties while being committed to protecting the sovereignty and integrity of this great nation. The Ministry of Home Affairs, in an affidavit, referred to the views of Prime Minister Narendra Modi on shedding the colonial baggage and said he has been in favor of the protection of civil liberties and respect of human rights, and in that spirit has scrapped over 1,500 outdated laws and over 25,000 compliance burdens. On July 15, 2021, concerned over enormous misuse of the colonial-era penal law on sedition, the Supreme Court had asked the sender why it was not repealing the provision used by the British to silence people like Mahatma Gandhi to suppress freedom movement. Agreeing to examine the pleas filed by the Editors Guild of India and a former Major General challenging the constitutionality of Section 124A in the IPC, a bench headed by Chief Justice N.V. Ramana had said its main concern was the misuse of law leading to rise in number of cases. The non-bailable provision makes any speech or expression that brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India a criminal offence punishable with a maximum sentence of life imprisonment. Let's hope that the Supreme Court's decisive order putting the sedition law in abeyance will set the ball rolling for preventing the misuse of the law.